Okay, welcome back, guys, to day 2 coverage of the Freedman trial, and this is going to be the final update because the trial wrapped today. So, joining me today is Allison Herrera. She is the Indigenous Affairs Reporter for KOSU, and you also do a lot of freelance work, right?
I'm currently working on a podcast for Bloomberg and iHeartMedia called In Trust.
Awesome.
Which is about Osage Nation's mineral and head rights and how Osage land ended up Osage land ended up in non-Osage hands. That's the easiest way to put it.
Gotcha. Well, thank you so much for being on the program today.
Thanks for having me.
And for you guys, I'm going to go the same thing that we did yesterday. I'm going to do today. I got a couple of disclaimers just for if you're tuning into this live stream. So on the MCN AG side of the case, the Assistant Attorney General, Clint Wilson, is my brother-in-law. I have not discussed this case with him in any way or anything, but that's just in the interest of transparency. I am related to him. So that was a disclaimer we also did on the previous day's coverage. Let's see. The reason we're doing it this way is because the court doesn't allow any electronic recording devices or any type of recording devices at all in the courtroom, so we can't show you any actual video from the trial. So it's just me and my notepad and writing down what happens, and then we go through it. At any time while I'm going through the chronological events, if you have a question, Allison, just feel free to jump right in. And then after I get through all of everything that happened in court, we're going to have a little discussion about the political ramifications of the decision in this case and where it could go from here and those type of things. So to start off with, we left off yesterday with the AG was going to cross-examine Miss Grayson. So that's the first thing that happened. There wasn't really any new information introduced from that cross-examination. Miss Grayson was asked why it took her so long to apply for citizenship and et cetera, et cetera. And she said she's been working with her Freedman group for the whole time with various people trying to get citizenship. They also, she admitted that when she applied for citizenship, she used the Freedman roll, not the Creek by Blood roll. But that was basically information that we already had from the previous statements. And so nothing new really in her cross-examination. Then they moved on to Mr. Solomon Simmons called Nathan Wilson, who is the director of the citizenship office, basically. He's not on the citizenship board. He's the director of the department. And just for the audience, in case you don't know, there's a board for citizenship that makes all of the decisions about citizenship, but there are also a department underneath of them that the functionaries, they help people with their research and things like that to get them citizenship, and there's office managers and all that stuff. So there's a separation there, though. None of those guys that are like the director or the managers, they don't make the decisions on who gets citizenship. The board does. So he was called. Also, and I'm just going to list the people that were called to the stand from the citizenship office because their testimony is all functionally the same. By both parties, Mr. Solomon Simmons and the AG, they both asked, what criteria did you guys evaluate the citizenship on? And all of them were very careful to say that they were not rejected based on the fact that they were submitting their lineage back to the Freedman rolls. They were rejected because they could not show that they had a lineage to the Creek by Blood rolls. So that was the information that they were trying to get across. But they called Nathan Wilson, who is the director. They called Leonard Gouch, who's on the citizenship board, but he wasn't at court. So instead they called Leanne Nix, who's on the citizenship board. They also called, let's see here, just moving down, Andy Proctor, who is the office manager for the Jinx Citizenship Office, the office in Jinx there. All of them gave the same testimony. The only wrinkle there was when Nathan Wilson was on the stand, and he told Mr. Solomon Simmons that there were other applications before this case where people had referenced the 1866 treaty in their attempts to get citizenship. And he said that they had consulted with the AG's office, and the AG's office had told them that they should follow the MCN Constitution and the Code. So that's basically what all of the testimony was there, is that they utilize, you have to trace your lineage back to the Creek by Blood rolls, and anything else, they don't consider it. And they never received any training on the 1866 treaty. They weren't given any instructions to consider it, etc. So after those witnesses were called, they moved to closing arguments. So in Mr. Solomon Simmons' closing argument, there are a couple of wrinkles here, but he maintained what he stated in his opener, which was that the 1866 treaty is the law of the land. Now, we spoke before in the previous live stream that he said that, and Allison, just one moment, I'm going to click this other tab here that has the Title 7 for the audience. So we spoke before that Title 7 was mentioned, and in Title 7 it says that the court can only remand any determination by the Citizenship Board unless it finds that the determination is arbitrary and capricious. And if you guys remember, I was saying that DeMario has to prove that, right? That's one of the things he has to prove for his case. So, with that being said, in his closing argument, he addressed that. So how he addressed that is he's saying that since the 1866 treaty is the law of the land, right? The 1866 treaty should be the relevant law to consult for the Citizenship Board, right? And since they didn't consult the 1866 treaty, that is why their decision was arbitrary and capricious, because they, instead of the code, he's saying that the 1866 treaty has supremacy over the code. So that's how he kind of closed that loop that we were talking about, where it's like, how is he going to do that? So from his perspective, that's how he did it. When it switched over to MCN Attorney General, not Roger Wiley,
Jerry Wisner.
Jerry Wisner, thank you. I had a brick wall there. Ms. Wisner's closing arguments centralized on this, and this is an argument you'll hear in relation to the Freedman issue a lot. So her argument is the code has supremacy, and the reason is the Constitution was authorized by the Indian Welfare Act. Okay.
The Oklahoma
yes,
Indian Welfare
the Oklahoma Indian Welfare Act. So what she's saying is Congress passed the Oklahoma Indian Welfare Act, and that gave tribes the ability to self-determine and write their own constitutions, and that's why the Constitution should be followed instead of the 1866 treaty. So, with that in mind, DeMario, so after she was done, DeMario got a moment to rebut what her closing statement said, and he got up and he pointed out some Supreme Court cases that delineate the little wrinkle with that, which is one of the things that was mentioned in McGirt, and also, let's see, what's the other one? I'm going to pop this up really quick, Allison, just, where is it?
You do you.
Well, I'm sorry you can't see this either, but this is for the audience. So in McGirt, one of the things that they stated was that the abrogation of a treaty by Congress must be clear. They must be specifically doing that. There have been other cases before the Supreme Court, such as this case that's on the screen here. Let me just pop it up. United States versus Dion, and which Mr. Simmons also mentioned, says we have required that Congress' intention to abrogate Indian treaty rights be clear and plain. There is also another one, Minnesota versus Millie Locke's Band of Chippewa. But that, so what Mr. Simmons is saying there is that you can't, or from his perspective, his argument is that you can't abrogate the 1866 treaty with the Indian Welfare Act because it's not specifically, the language of that act does not specifically abrogate that, okay? So, let me see, does that bring us to the end? The judge said at the end of the trial that she knew that people wanted the plaintiffs wanted her to rule from the bench on this matter, but just like with the motion for summary judgment that was done in December in this case, she said she's going to consider the issue, she's going to do it as fast as she can, but she's not going to rule today. So, with that being said, Ms. Herrera, do you have any questions?
Well, she said she's not going to rule today, but my question is, when is she going to rule?
Yeah.
And then my further question would be, depending on how she rules, what other tribal remedies does either side have in this case? Because one of the things that struck me when I was listening to yesterday's testimony is that there was a lot of, for a case that's really, that's basically an administrative appeal. That's really
right.
A case that's about, I don't agree with what the Citizenship Board did. I don't agree with their decision. I'm appealing this decision. Mm-hmm. The case is definitely one, to me, and I think Angel Ellis, our colleague, said, is very much an advocacy case to make, and so I'm wondering if, what remedy both sides have, and for a case that's, supposed to be just about an administrative appeal, it seems like the plaintiffs really want this case to end up before a federal court, and because they want to exhaust all of the tribal remedies.
Yes.
And so when I was listening to that yesterday and listening to the frequent mention of the 1866 treaty and Article 2, I immediately thought about it. Like, he wants this to be on the record so that if the judge rules against the plaintiffs, then this case can go to a federal level.
Right. I think you're spot on with that strategy. We got a question pop up here in the chat. I'm just going to read it from T.Y. Pearl. Have the plaintiffs in the case ever applied for CDIB cards through the BIA? Now, I don't know. That wasn't brought up and wasn't asked in the trial in any way. I don't know if they could. I personally just don't know if they could get CDIB cards through the BIA. I'd have to pull the regs on what they can apply for. Do you know, Allison?
I have never heard of that before. A CDIB card, from my understanding, is one that is always issued by a tribal nation. You have to prove, you have to prove your lineage. You have to prove your heritage. Your descendancy to be able to get that. The only thing I could think of is if you're a state recognized tribe, or if you're then you get, but that again, that's not a CDIB card. You get, there's a letter that you would get from the BIA,
right?
But it's not a CDIB card.
Mm-hmm. Yeah, I don't know how that would work out. So this is something that, the A.G. Wisner presented her closing argument where she cited the Oklahoma Indian Reorganization Act. And as she was going through it, this occurred to me about just the strategy of that argument. And when DeMario asked for time for a rebuttal, I was like, oh, he's going to bring it up. And he didn't bring it up. He brought up what I mentioned, the other Supreme Court cases that talk about the abrogation of treaties through United States Congress. But this is also an argument that could be made from that standpoint, is that because the Oklahoma Indian Reorganization Act argument is an argument about sovereignty, saying that this is tribal sovereignty, right? But you could make the argument on the opposite side of that to say that the act of signing a treaty, right, is like one of the ultimate acts of a sovereign. It's two sovereigns signing a contract with each other. and the damage that would come to your sovereignty from reneging on one of the contract there. That's basically the motivation for the Supreme Court's decision in the United States position on McGirt, is that, we're not going to damage that. We can't damage our treaty making process. If we become internationally unable to make treaties, we can't do anything, right? And that's something that Mr. Solomon Simmons didn't bring up, but I was thinking to myself, I was like, how is that going to work if the court rules in favor of the argument that the Oklahoma Indian Reorganization Act or Indian Welfare Act did grant tribes the ability to, in some way, abrogate portions of treaties or something like that? You know what I mean? Like, how will that reflect on all of the other legal precedent that's going on with all of the other and unheard of yet lawsuits and court cases that are going to stem from the McGirt decision, right?
Mm-hmm. And I think, I think another strategy from the plaintiff side is that they are also, I went back and I was reading my notes in preparation for this live stream, that they are, I think they're pretty smart to bring up the McGirt decision, because the McGirt decision references that same treaty and made a decision based on that treaty, saying that, it was the supreme law of the land, and it proves that, Muscogee Nation's, Congress never disestablished the reservation. So if the defendant, if Muscogee Nation can rely on that, and put forth that argument, in front of the Supreme Court, then how come they can't, what would make, why then is the Constitution in conflict with the treaty? I mean, I felt like, Professor Pratt yesterday did a really, I learned some things during when she was laying out the history about, the Dawes rolls and, the Freedman rolls and the by blood rolls, and then how, I think a really great point that she made is, under the Oklahoma Indian Welfare Act, yes, tribes were able to make their own, were able to write their own constitution, throw off the yoke of the United States. But that constitution still has to be approved by the Department of the Interior.
Right.
And I could see, I could also see, Mr. Simmons writing a letter to the Department of the Interior. I'm not, or, somehow, obviously like getting them involved in this case. That would be going to the federal level.
Well, and any of those executive branch actions are reviewable on the judicial side, through all those levels. The Freedman issue too is, and for the audience, there's a link in the description of this video to the video about what is the 1866 treaty. And at the end of that video, we kind of touched on that, and it was before the McGirt decision came through, but it was during that period where it was being argued, and I think it was actually when it was the previous case. But that was one of the things that I pointed out in that video, is that there is other stuff in the treaty in relation to the Freedmen specifically, that what effect is that going to have on the tribe, even if they win this case, right? Or, because the 1866 treaty has things that the tribe agreed to at that time, and that we don't agree, that the tribe currently does not agree to, right? And so what's the impact going to be there? And a lot of people in the legal community, when the McGirt decision came down, were talking to me, and they were like, well, the tribe's got a problem now because they've got to get caught up with this, like the citizenship and other things is not kosher. It doesn't match up with the 1866 treaty. Let me check and see. I think I've got some questions here in my chat. Tribes do not issue CDIBs. That's correct, T.Y. Pearl. But that's why I was saying, like, the federal government, though, I'd have to pull the federal regs on what qualifies for an application there. I don't think if you're on the Freedman roll, you can get a CDIB. I don't see how it would be possible. Treaty doesn't require citizenship to be given, only that if citizenship is granted under the laws of the Muscogee Nation, they have to be granted full citizenship. Change my mind. Well, I don't have a position on it one way or another, and the federal government is going to probably get involved in this case after it goes through all of the tribal courts, unless there is a scenario where The district court affirms that the 1866 treaty should be considered. It's appealed to the Supreme Court, and the Supreme Court changes its precedent, and at the Creek Nation Supreme Court changes its precedent and says, yes, we're going to consider the 1866 treaty and the Creek Freedman rules in addition to the by blood rules or something like that, or the Constitution of the Creek Nation could get amended by citizens. Those are all possibilities.
I was just going to say, I mean, I could see the judge saying, you need to go back and fix the Constitution, or you need to go. I wonder. I mean, maybe this wouldn't happen, but this would be a scenario. The judge would say, okay, I'm going to rule, I'm going to say you need to go back and you need to fix this 1979 Constitution that you wrote and passed and got approved to incorporate the language of the treaty. And I could see then the tribe maybe going to the voters and or putting this to council, putting this to the voters and asking them what how they should act. I mean, when I've spoken with Principal Chief Hill, he's always maintained like this is something for the citizens to decide. Like I can't make this decision, and I think that is I think that's something that they are probably going to have to do. They're no matter how this case gets decided upon, I think that there definitely needs to. I think that there should be, and there probably will be some discussion within the Muscogee Nation about Freedman citizenship. And Mvskoke Media you guys did that great video. I think it was 3 or 4 years ago where you talked with 3 citizens and asked them their opinion on Creek Freedman citizenship, and 2 of them explained why they didn't think it was a good idea, that we're a sovereign nation, we don't want the federal government telling us like who can and who can't be citizens. And then you had that one person at the end that was like, they should be citizens, like what we should make our own, really putting forth the case that like, yes, we are sovereign, like we have the ability to do this, we should be able to admit the citizens in the tribe. And so I guess I'd be curious to hear from you, Jared, like what you've heard from citizens about this trial and what they think should be done. And I mean, I've some of my time preparing for this trial was spent on Twitter and hearing from Muscogee citizens who feel like the nation needs to do the right thing, like admit them as citizens. They're part of the tribe. I mean, I heard Rhonda Grayson talk yesterday about Mvskoke, her ancestor, and how she spoke Creek, and she does language classes. I mean, I think like that, making this case that we've always been part of the tribe. So right,
yeah. I mean, that video that you referenced, the Creek Freedman video, it's on our YouTube too. And I want to mention really quick, T.Y. Pearl wants me to talk about the language of Article 2, and I'm going to get to that in just a second, T.Y. Pearl. That video actually came because we were contacted by citizens through social media saying, hey, Mvskoke Media isn't putting our voices out there and everything. We're like, okay, great. Let's schedule a time. We'll do those interviews and put that video together. So, as far as it sounds like the question is, if there was an amendment today to do it, which way would the vote go? I actually don't have any idea which way it would go. My instinct is to say that they wouldn't vote for it, right? But who's to say? I've been surprised in the past, and there are a lot of citizens now who know more of the history who do see that there is a problem with the way things were done, right? But it's one of those issues. It's also like the blood quantum and full citizenship issue, right? There are a lot of citizens who know the history and everything, and they're like, we need to get blood quantum out of the tribe, like out of the Constitution altogether. And then there are other citizens who, for whatever reason, maybe they don't know any of the history, or they think that the blood issue is like some type of science or something like that, that they want to keep it in because they're like, we want to keep our full bloods and et cetera, right? So I don't, and who knows which way that vote, if that came up as an amendment, I don't know which way that would go. There are a lot of citizens that are also like the at-large citizens are a big voting bloc now, right? So who knows which way they would go with their voting, because a lot of this is also tied in with the politics of ceremonial grounds or where your tribal town is, right? And so once all of those citizens that have been disconnected from that, it's going to affect how they see this issue even more so. But let me jump over here because T.Y. Pearl's, this is something that he's brought up several times. I'm going to look
T.Y.
at... Yeah, well, it's T.Y. Pearl is what his screen name is. So he's brought this up, and he's saying Article 2 states, as may be permitted by the laws of said nation to settle within the limits of the jurisdiction of the Creek Nation as citizens, right? Let me bring this up full screen. So, and he's saying that part of the treaty, it doesn't say that the tribe has to give them citizenship. It's saying that it can.
I've heard that argument before as
well. I've got the language up on the screen right now. I'm going to read through it, and we'll see if we can find if there's anywhere in there that's explicit, right? Article 2 says, the Creeks hereby covenant and agree that henceforth neither slavery nor involuntary servitude, otherwise than in the punishment of crimes, whereof the parties shall have been duly convicted in accordance with laws applicable to all members of said tribe, shall ever exist in said nation. And inasmuch... Oh, well, hold on. Let me break right there. So that part is pretty clear. It's saying that the Creeks are entering a covenant to not have slavery unless it's a punishment of a crime. Okay? There, we agree on there. And just so you know, I'm going to scroll up really quick. I'm getting this from the Tribal Treaties database from the Oklahoma State University Library.
I'm reading the same one.
All right. Okay. All right. Here we go. Where were we? And inasmuch as there are among the Creeks many persons of African descent who have no interest in the soil, it is stipulated that hereafter these persons lawfully residing in said Creek country under their laws and usages, or who have been thus residing in said country and may return within 1 year from the ratification of this treaty, and their descendants and such others of the same race as may be permitted by the laws of said nation to settle within the limits of the jurisdiction of the Creek Nation as citizens thereof, shall have and enjoy all rights and privileges of native citizens. Okay? So there is in there, you're correct, and it's part of that, saying that may be permitted by the laws of said nation to settle within the limits. But you got to keep going, because later on it says, shall have and enjoy all rights and privileges of native citizens. That's pretty explicit. It's saying that they shall have them, right? Mm-hmm. Now, prove me wrong. or what did you say there, T.Y. Pearl?
Yeah.
Change my mind. change my mind. Or it's not my mind, change the treaty's mind. That's pretty clear. I'm going to go ahead and finish out the section there. Including an equal interest in the soil and national funds, and the laws of said nation shall be equally binding upon and give equal protection to all such persons and all others of whatsoever race and or color who may be adopted as citizens or members of said tribe. So it's pretty cut and dried there. It's saying the tribe agrees, we're not going to have any slaves, no more slaves. Anyone of African descent that's living, let's see here, lawfully residing in said Creek country, they shall have and enjoy all rights and privileges of native citizens, including equal interest in soil and national funds, etc., etc. So,
and my question then to I wonder if then, going back to the 1979 Constitution, what was the motivation then? If the treaty is in conflict with the Muscogee Nation's Constitution, what was their motivation to say that citizenship needs to be based on the Dawes, of lineal descent on the Dawes rules. That you have to show, your descent on the by blood rules rather than the Creek Freedman rules. I wonder what their motivation was for that.
Well, you'd have to basically ask everybody who is alive. In fact, that Jason has on the Muscogee Pod a good podcast about with some of the guys who were instrumental and created the 79 Constitution. So go check that out. They don't really talk about this issue, but if you could find as many of those architects and people who constructed it for the vote, right, and ask them what the motivation was, and if they wanted to tell you that, that what it was, because I can tell you from all of the stuff that I've seen, the 1866 treaty was way far in the rear view for a lot of people at that period, right? That it wasn't something that was mentioned in any of the literature or anything like that. I don't know how much knowledge there was about what it actually said, because the tribe had been operating on its own without any federal help or anything recognition.
I was just going to say, you have to remember the time that treaty was written. I mean, when the time that Constitution was written, like, tribes were still coming out of this era of like not having anything, like you said, not having any, operating under these old constitutions that, really didn't, permit them to, I think, exercise their full sovereignty. I mean, correct me if I'm wrong.
Yeah, well, and even the testimony and T.Y. Pearl's kind of talking about right now, that the Constitution had to go through the BIA, and they had to sign off on it. And
that was my next question.
Miss Pratt's statement was, she thinks that was a mistake, that the tribe should have been told it's in conflict with the treaty. And not for nothing, she's probably 100% right on that front, is that the tribe should have been told about the 1866 treaty. Hasn't been anybody in we have some history stuff on our From the Vault about that period. Nobody mentions the 1866 treaty. Until the run-up to the Murphy case, pre-McGirt Murphy case, that's when people started coming out of the woodwork, and also the Ron Grant Freedman case, people were talking about the 1866 treaty. So they might not, the powers that be might not even known about it. And if you look at the narrative in this case too, this is the other thing, because this happens a lot at the Nation that I have seen. So you have two stories that are coming out of both sides. The plaintiff's side is saying, we applied for something, we applied for citizenship, and we gave extra information, right, to try to educate the officials about this thing. And in the testimony today, all of the election board officials, right, they all testified. I don't know anything about 1866 treaty. I wasn't told anything about 1866 treaty. I wasn't given any training on the 1866 treaty, right? They were familiar with the Creek by Blood rolls because that's what they were told you are to use, right? And the Constitution, the Code told them to do that. So from the plaintiff's perspective, right, Miss Grayson kind of said this. She was like, I assumed that they would take this new information and it would be evaluated.
That this would be something that they would want to know about.
Yes.
Mr. Kennedy
and the testimony on the other side from the election board officials, they all testified we weren't going to look at that at all. We don't look at that. It's not what we were told to look at, right? And it's irrelevant. It's like if you brought them evidence that you were a citizen of McDonald's. That doesn't have anything, you know what I mean? From their perspective, they're like, what's this McDonald's? I don't even know what this is, right?
And that's what makes, at the heart of this case, it's to them, it's purely an administrative matter. It doesn't have anything to do with the treaty. It's like, these are the rules that I follow. These are the things, they could have been probably reading from like an employee manual or like a job description saying like, these are the rules that we follow for citizenship. And this is how we do it.
Well, and some of this litigation could have been circumvented, right? Because in the testimony we heard today, we know that the director of the Citizenship Office, what's his name?
Nathan
Wilson, I think.
Nathan Wilson.
Yes. He spoke to the AG about this matter. So, and I'm pretty sure the AG can do this, but I'm not, a lawyer, but I'm pretty sure the AG could have gone to the Creek Supreme Court, right, and got a ruling on this issue so that she had a Supreme Court thing to take back to the Citizenship Board and say, we've brought the issue to the Supreme Court to get an opinion. This is their opinion about it. And then the lower court litigation and all those things wouldn't have to happen if you already had a Supreme Court opinion about it. And that's something that could have been filed in absentia of any case, right?
Yeah.
But that wasn't done.
I mean, we talked about this yesterday. This is just an observation. It felt to me very much like that the A.G. Wisner, that the Muscogee Nation didn't seem as prepared as they should have been in arguing this case. I mean, that is just like from the cross-examination of Dr. Pratt. I remember, Clint Wilson asking, Professor Pratt, how when she was asked to be a witness for the plaintiffs, and it seemed to me like they didn't have enough time to depose or prepare for them to depose her, and prepare for their cross-examination, as we both saw yesterday, where Solomon Simmons objected to several questions about when he asked her about, did she know anything about the creation of the Constitution? And, it felt very like they wanted to be able to dig into some of that, but then, maybe we're not as prepared as they should have been to ask those questions.
Right, absolutely. Well, that's what it seemed like, and there was a lot of kerfuffle about the discovery in this process after that December hearing. That reminds me, I was going to show you guys. And Allison, do you know how to look up cases in the Creek Nation District Court?
What you have helped to educate me.
All right. Well, I'm going to do it for the audience right now.
Please tell the audience.
Yeah.
Because as somebody who's not a Muscogee Nation citizen who wants to know what's going on in Muscogee Nation Court, I would love to have a tutorial, Jared.
Okay. So here's how we do it. I'm going to open a new tab for the audience, you guys. You go to creekdistrictcourt.com. Court.com. Let's see if that works. Yes. And then you'll get to this page. So when you get to this page, you go to court. Let me make this a little bigger. It's kind of small. You go to court calendar at the top. You click that. This page will come up telling you have to log in. All you need to do, though, is just click this little button. There's no actual login. You'll get to this page. At this point, you're like, what happened? Did it break? You need to go up here to searches at the top. Actually, I didn't make that full screen. Let me back up because I didn't have that full screen. Sorry, guys. Creek District Court, court calendar, login button, searches, case searches. Now, if you know the people that are in the case, you can go to by party, and then you put in this information. Like, for instance, we're talking about the Rhonda Grayson's case, right? So I'm going to put in Grayson, Grayson, and then in first name, I'm going to put in Rhonda, Rhonda. And then we hit enter. And you see here, the case comes up at the bottom. If you click the case number, it will bring up this page that has all of the information on the front page about when the case was, when it was filed, what type of case it is, etc. If you want to see all of the events that have happened in the course of the case, you need to go over here to the ROA here in the bottom here. You click that. This has everything that's been filed in this case. Now, we were talking about kerfuffle about the discovery, right? So I'm going to scroll down here. Here you can see request for recusal, order of recusal. So somebody left the case. One of the previous attorneys left the case. Notice of appeal. Order denying petitioner's notice of appeal. Citizenship board request for scheduling order, etc., etc. Let's keep going down here. Oh, so much stuff. Here we go. So we have motion to compel defendants' discovery responses. We have, they were going to call principal chiefs to the stand, but it got quashed. Quash means they're not going to do that. They're quashing the subpoena.
And again, that goes to, I think, the high profile nature of this case, or Mr. Solomon Simmons really making a discovery hearing would be one of a very boring thing to pay attention to. Like normally you wouldn't go out to the courthouse to cover that. But I think, again, part of his strategy is to make a big deal of those things.
Yes.
And then also say, oh, we're gonna subpoena the chief. But you can't really do that because he's not the one that makes those decisions.
Well, and if you wanted to find out why the court, well, I'm going to go ahead and jump ahead. But you see all of these things that were filed, guys. If you want to get the actual paperwork from each of these things, like this order denying plaintiff's motion for summary judgment and denying plaintiff's motion to strike defendant's surreply, if you want to read that, you need to print this list off, right? Highlight the stuff you want, bring it down to the district court, and then they will have you pay an amount of money to have it printed, right? Mm-hmm. And then you can have that and read it. And there's, as you can see, so many filings in this case. We didn't go over there and pull all of these filings, right? We didn't go through and find out these discovery requests and things. And there's also there was a discovery conferral agreement, right? Plaintiff's motion for discovery conferral agreement. And that was ultimately, agreed upon. Which just means that both sides are going to have a meeting where they're going to describe what they're going to do in their discovery. So the discovery was kind of fought over a little bit, right? Mm-hmm. But that's how you get documents out of the court. It also is how, if you're at home, and so for my process, for you guys, I'm going to keep checking this and calling the court every day that the court's open and asking them, has the judge issued a decision in, let's see here, what is it? CV 2020-0034. When they say yes, I'm going to go over and get a copy of that decision. But if you're at home, you've seen how to log into this. That when that order is filed in the computer system, it'll appear on this list, right? So at that time, you'll know, okay, the decision has been made, the order has been published, and you could even go down and get one. There is a lag from when, the reason I call the court every day is because there is a lag between when the judge will actually make the order and publish it, and then it gets entered into the computer systems. They got like a stack of papers that gets entered in. And so sometimes it won't appear on the computer system, but you can go get a physical copy. So that's why I call them every day. And if you want to call them every day, knock yourself out. So, but that's basically how this court stuff works down here. Sometimes, I don't want to, where are we at? We're at 43 minutes. We should probably wrap. I was going to go into a discussion about how sometimes the things online in their court system will be different from what's actually filed at court, but that's a whole nother can of worms dealing with the DUI story. Let me check and see if there's any questions here. TY Parole is he has a lot of statements here. You guys should go check out the chat. He's flaming hot mad about it.
What is he mad? What is he mad about?
He and he might be right. I don't know, but this is what court is for. He's saying it's in. There's. Let's see. Let me back up here. May be adopted, not shall be adopted. The treaty is not in conflict with the Constitution. That's why it was approved by the BAA. They have no case, so on and so forth. So, if you guys want to get in there, go for it. And then we're going to have.
Maybe we should have a citizens forum on this, Jared. Maybe we should have a host of.
I would love to, and I would love to do stuff like that. The problem that we have with doing things like that, Allison, is, and this came up when the Freedom of the Press bill was going to go, the vote on to allow citizens to vote on the amendment was going before council. We got cease and desist because there is code on the books at the Creek Nation that Mvskoke Media is not allowed to do any political process, right? Like we can report on candidates and stuff like that, but we can't give any opinions or host anything where people are giving their opinions. That type of thing. It would be something where ideally we would want to get it cleared through the AG's office, or if Mvskoke Media had an attorney, run it through them and everything before we could do anything. So I think
that T.Y. Pearl and other citizens. I think that's a really great dialogue to have within the nation, and I think speaking as a maybe I'm speaking out of turn here. I'm a non-citizen, but
you are a native.
But I am native, and I have I listened to other people talk about this issue, and I think some people feel like that it gets unfairly categorized as a racial issue. And I'm not saying that maybe some people feel otherwise, but I have heard people say, I don't think that this is a racial issue. This is simply an issue of our sovereignty, and that's really important to me. I think that's a valid opinion. And then to hear Grayson and Kennedy and others like Ron Graham talk about their family and how they helped build this nation. Even I've talked with Choctaw Freedman, I've talked with Chickasaw Freedman, I've talked with Muscogee, with Cherokee Freedman, who feel like they have a stake in the nation as well. And I think this is an issue that even if the judge rules against the plaintiffs, it's not an issue that's going to go away. And I can guarantee you in other tribal nations, it's not going to go away either.
Yeah, it'll keep coming back up. There are, even beyond this particular Creek Freedman group, there are other national Creek Freedman groups that are even more, they're getting funding and stuff. They're going to bring cases. So the group that's in court right now is the Spear Tip. They're not the back of the shaft or anything. This case is going to get heard and heard and heard. Even if it goes to United States Supreme Court and somehow the whatever decision comes down that reaffirms what the Constitution or whatever says right now, they're going to keep filing. So they're going to keep going. Yeah, people are going to keep going at it, and I think, which is why Ron Graham said to me yesterday, he's like, I would rather us settle this in tribal court rather than go to the federal court, because he's kind of likened it to this is like a family. He's like, it's a family squabble. Why would you go else? You would solve it within the family. And I don't know how other people feel about that, but that's something that he said to me yesterday that really stuck with me. Yeah, and that's also an aspect that you don't see a lot in all of the filings and everything. We should wrap up, but I'm going to want to touch on one more thing, is that, in any type of movement, you have several fronts. And the legal front is part of it, but there's also should be a community outreach front where you would expect freedmen groups to go into these communities and try to build these bridges and have this dialogue outside of the court, outside of the government, just socially, to say, hey, can we count on your support, or what can we do, to mend whatever fence has been broken or whatever, right? Because it's not racial argument. There is also a component where, just like we're talking about it right now, what we don't see a lot of, right, are Creek citizens at these protests, right? And it's not because some people wouldn't go. I'm assuming it's because they're not being contacted. There's not that coordination between the freedmen groups and the citizens that are citizens already, right? And that's something that I would expect to see built up. It needs to happen in the future for any type of, if you want to term it a civil rights movement or a social, just like Ms. Pratt pointed out, right? Race is a social construct. And one of the ways that you combat any type of racism or misbeliefs about a race or anything like that is you have to go into the social structure and educate and speak and say, hey, I'm just like you, like to see that part, as long as the two parts are physically and kind of ideologically separated and they never intermingle, right? That was the whole objective of segregation. The civil rights movement was to keep them apart, and then that way both sides don't realize that there's another structure over them holding them down, right? So, but thanks so much for coming on the program today.
Oh gosh, thank you so much for having me. I'm surprised that it's not going into a third day, but I bet you're relieved.
I am relieved.
I felt like I got freezer burn yesterday being inside the.
when you've seen previous cases come through, you know, after a while you're like, okay, here we go again. You know, it's going to be because the arguments don't fundamentally change, and so, but it's a long day. It's a long day. It is. And for you guys watching the program right now, as soon as this decision is dropped and I get a copy of it, we'll have a video up kind of dissecting the decision and what the judge says and doing projections on what may happen next. It's probably whichever way is going to go to the Supreme Court. I can almost guarantee it. And then if you're a citizen out there, you know, this discussion has made me think. If you're a citizen out there and you want to voice your opinion on the Freedman issue, right? This case even in particular, you know, shoot me an email. My email is jmoore, that's the letter J, MOORE at MvskokeMedia.com. And that's just like our channel name, Mvskoke, the traditional spelling. So
and you can email me too. It's Allison, ALLISON, at KOSU.org.
Yeah, so hit us up, say, hey, I've got something I want to say. Because that's, for me, in my opinion, that is my job, is to be the megaphone for citizens who feel like their voice isn't getting heard. That's the most important thing I can do. With that being said, thanks so much, Miss Allison Herrera. I look forward to all the coverage coming out of you in the future. And you guys tune in next time. For next week, we have on Monday a live wire with a group that is having some fundraiser to refurbish the Council Oak Park. So tune in there to see what that's all about. And with that being said, Mado, and we'll see you guys later. Chihicha, please.